Okay, well, we're back, and this is going to be part two of our chapter 12 lecture on the legal process, including bail and the right to counsel, etc. And we had just discussed a little bit about, prosecutorial discretion and selective prosecution and vindictive prosecution, and now we're gonna turn into probable cause and talk a little bit about detention. So again, the first step for a prosecutor following the arrest of an individual without an arrest warrant or formal indictment by a grand jury is a judicial determination of whether there is probable cause to detain the individual for an extended period of time. Now, in the case Gerstein versus Pugh, and it was discussed a little bit more in Chapter 5, the Supreme Court held that Florida law permitted a suspect to be held for a month or more before being taken before a judge to determine whether there is probable cause or whether that probable cause constituted an unreasonable restraint on liberty in violation of the Fourth Amendment. Now, the U.S. Supreme Court stated that the Constitution requires a judicial determination of probable cause as a condition for an extended restraint of liberty. And this non-adversarial process is going to be called, basically, it's a probable cause hearing. Sometimes you might hear it called in the legal field a Gerstein hearing, because that's the name of the case. But it's also a lot of times referred to as a probable cause hearing. And this hearing is a non-adversarial type hearing, but it must be held promptly following an arrest. And we'll talk about what promptly means, because, of course, a lot of times these Supreme Court cases, they settle some of these vague areas that we talk about. So with that said, in another case, County of Riverside versus McLaughlin, the U.S. Supreme Court defined what promptly meant and basically held that a 48-hour period of delay is considered presumptively reasonable, a reasonable period of time within which to conduct that hearing. So basically, you have 48 hours in order to have that probable cause hearing. So you can detain someone for that 48-hour period. And the 48-hour requirement is there because it balances the interest in protecting society by detaining a suspect for that time period against the risk that an overly lengthy detention will unduly interfere with that person's, let's say, their job or income or personal life, or more importantly, their freedom, right? So again, a lot of times you hear that phrase called a Gerstein hearing. But again, in County of Riverside versus McLaughlin, they came up with that 48 hours. Now, there are some other things, like it excludes weekends and holidays. So while it's 2 days, it can actually be a little bit longer because it excludes holidays too. So depending upon when the custody portion takes place, it could be actually as long as 7 days. And on page 435 in your textbook is the case, the County of Riverside versus McLaughlin case. And part of this case, part of this probable cause, or the time between the arrest and the probable cause hearing, allows law enforcement to undertake, if you will, the administrative steps incident to arrest. And one of these steps includes paperwork like searching the suspect or inventorying property, fingerprinting, photographing, and sometimes it might even be combined with that first appearance, but it may be lab work or conducting a lineup, etc. So part of it also includes this form that you see here, and it's called a probable cause form. So in California, specifically in San Bernardino County, but almost all of California, in that 48-hour period, we have to fill out this form, and you can see it's basically a probable cause declaration. And here is the arrestee's information, some of the facts, and you can attach more information or a report to this, and you sign it and you send it over to somebody at the custody facility that's going to evaluate this and determine whether or not that person should be kept in custody, all the way to their hearing. They still have the opportunity to bail out, etc. But if they can't bail out right from, let's say, the jail, then they'll have to wait until their first hearing. But this is the form. This is a probable cause form. So the next thing that happens, or the next step following an arrest, is typically the first appearance or the initial appearance. And the first appearance is triggered by the filing of a complaint, which is a sworn statement by the prosecutor charging the defendant with whatever they're going to be charged with, but a specific offense. And again, this needs to be conducted as well without unnecessary delay. And states differ a little bit on the permissible time between the arrest and first appearance. But again, the Supreme Court has set the outside limit at 48 hours in that County of Riverside versus McLaughlin case. And the court has held that a confession obtained after failing promptly or to promptly present a defendant to a magistrate is also going to be inadmissible. And that initial appearance also has some purposes. So, why do you show up at that initial appearance? Well, here's 4 primary purposes for that initial appearance. The first one would be as it relates to criminal charges, meaning informing the defendant of the precise charges against him or her. The second would be constitutional rights, informing the defendant of the right to counsel and other rights. And this includes entitlement to an attorney and the right to consult with an attorney, and the availability of pretrial release and bail, the right to a preliminary hearing, and we'll talk about what that means in a little bit, and a speedy trial, and the right against self-incrimination, and the right to exclude unlawfully obtained evidence. All of these things can happen at that first hearing. And again, sometimes it's different from state to state. Another one would be the pretrial release, which again, I kind of said in the constitutional rights, which is the setting of bail. A determination is going to be made whether to release the defendant from custody prior to trial. And if not, the judge will fix the amount of bail or establish conditions of the defendant's pretrial release. And then, of course, finally, attorney. And we talked about that as well in the constitutional rights. A lawyer or an attorney is appointed for anyone who can't afford one. And now you can hire your own attorney, but regardless, if you can't afford one, one will be provided to you by the court. Now, in some other jurisdictions, a defendant is provided the opportunity to enter a plea of guilty or not guilty at that first appearance. In others, defendants may be required to enter a plea to the criminal charges. So, it kind of depends what state you're in. So just kind of these are just kind of the basics. Now, in the cases of misdemeanors, typically defendants plead guilty or they plead out. And Why do you think that might be at this first hearing? A lot of times the defendants will plead out. A lot of times it's to dispose of the case. Not always, but a lot of times that's what happens. Okay, so let's talk a little bit about pretrial release. So in England, the practice at the time of drafting the U.S. Constitution was that people who had been arrested and who were awaiting trial could be released from detention by depositing money or title to their property to the court. And that sounds, I mean, think about how things have kind of evolved. That kind of sounds familiar, right? And a failure to report to court would then result in the forfeiture of the money or the forfeiture of the property. And that is kind of morphed, if you will, throughout time to what we call now as posting bail. And we'll talk a little bit about posting bail. Bail is basically a mechanism for those who are awaiting trial to be released. So again, that philosophy has led to this modern court practice. Again, we call it posting bail. And the Constitution provides for bail in the Eighth Amendment, right? Which states that excessive bail shall not be required. And this bail provision has not been incorporated into the Due Process Clause of the 14th Amendment. And most state constitutions, however, create a right to bail in almost in many cases, but specifically not in capital cases. And the fundamental nature of bail was recognized by the U.S. Supreme Court in a case called Schlib versus Quibble, in which the court observed that bail is, of course, it's a basic system of law. And the Eighth Amendment's basically prescription of excessive bail has been assumed to have, application to the states throughout the 14th Amendment. But, again, in another case, Stack versus Boyle talks about the preliminary purpose. So the Schlib versus Quibble case is kind of saying that this bail thing is basic to our system of law. In the case of Stack versus Boyle, it kind of says it a little bit different. It talks about the primary purpose of bail is to ensure that somebody shows up, that they come back for their trial. And then many of you have probably watched Dog the Bounty Hunter, right? Because, an amount of bail beyond that required to guarantee the defendant's appearance for trial might be deemed excessive. But we also know that sometimes people don't come back. They might post bail and they might do what's known as skip bail, or they take off. But a modern practice of requiring a bail bond or the deposit of a sum of money subject to forfeiture, again, serves as the assurance, hopefully, that the presence of the accused, meaning that they'll come back. And bail is set at a higher figure. It might be deemed excessive. But anyway, that's kind of the bail clause, if you will. There are some reasons to deny bail, but typically, we have the bail clause. So again, not all cases get bail, so capital cases don't. And there are some reasons that bail is important. I mean, you have to kind of think about it. 40 state constitutions deny bail to individuals charged with capital offenses. The U.S. Department of Justice, the Bureau of Justice Statistics, reports that between 1990 and 2004, 62% of individuals arrested for felonies in the 75 largest counties in the United States were released on what they call personal recognizance, or on bail prior to trial. So let's look at some reasons why. And of course, the higher the bail, the less probability the defendant will be able to post bail. But there are reasons that bail is viewed as important. And the first one is detention. Because an individual may spend several months in jail awaiting for their trial, and things are supposed to be speedy, remember? Personal hardship. Failing to make bail might strain family life and could result in loss of income, and somebody could lose their home or lose their car, or maybe the person in custody is the primary breadwinner, and therefore they need to at least be out and working pending trial, because remember, you aren't innocent until proven guilty, right? And then finally, the last reason on why bail is viewed as important to the defendant, at least, is preparation for trial, meaning that if you're released, you can help your attorney with your case. Balanced against the importance of bail to the individual is the fact that society has an interest in detaining individuals who may engage in criminal conduct, and the cash bond has historically been the principal form of bail in the U.S. So this money bail system requires that the defendant deposit an amount of money with the court as a condition of release, and the other one would be they turn to a bail bondsman and they get a security bond. And here the defendant's required to deposit 10% to the bail bondsman, and then they forfeit it if they don't make their case. So again, should we let suspected criminals out pending bail? Some people see it as a get out of jail free card, like in Monopoly. But what about it? Drug dealing, burglary, rape, murder. Should any of these people get out? I'm just asking the question. I'm not giving you the answer or posting it. I'm just kind of throwing it out there for you to kind of decide. So the types of bail, I mentioned it briefly. Money bail, again, this is where you deposit an amount of money with the court as a condition of release. Typically and more often used would be something called a bail bond. And this is usually 10% to the bondsman. And then the bondsman deposits the money with the court. And if you fail to show up, you forfeit your bond. And then the last one would be released on what we call OR, or own recognizance. And this is no real bail. You're just being released pending the hearing. So those are different types of bail. And again, the Eighth Amendment, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. And I have a little bit more, another video to the Eighth Amendment. Well, what about being detained without bail because you are maybe a super criminal or something interesting? So let's look at the United States versus Salerno case. So in 1987, in United States versus Salerno, the U.S. Supreme Court basically upheld or affirmed the constitutionality of what we call preventative detention. And this would be used or utilized for individuals who pose a risk of flight or a severe risk to the community. So preventative detention permits the government to obtain a court order providing for the pretrial confinement of a person who is awaiting trial. And roughly 17 state constitutions also have an area or some information that provide for preventative detention. So in this case, defendants Salerno and Cafaro were alleged to be high-ranking organized crime figures who were charged with 35 acts of racketeering, including fraud, extortion, gambling, and conspiracy to commit murder. And in this particular case, again, they were able to be detained without bail due to their level of criminal activity. So again, And the decision, when courts look at that, rests on several legal conclusions. And we'll talk about some of those. The first one would be, of course, would be due process, or more informally called the substantive due process, meaning the act does not constitute impermissible punishment before trial. Next, of course, would be procedural due process, that the defendant is permitted representation by an attorney, the right to prevent evidence, and the right to cross-examine witnesses. And then, of course, that it needs to fit within the Eighth Amendment. And remember that the bail clause does not provide a right to bail in every single instance, and does not prohibit the detention of a person prior to trial. So take a look at the Salerno case. It's pretty interesting. And a little bit more, well, what about being detained in, let's say, a short-term correctional facility? So an individual who is not released prior to trial is typically detained in what we call a short-term correctional facility. And a case that kind of adds a little clarification to that will be Bell versus Wolfish. And in this case, the Supreme Court held that while these detainees retain their constitutional rights, they are subject to reasonable regulations intended to ensure order and security in the institution. And the court cautioned that detainees have not been convicted of a crime and may not be subjected to arbitrary or purposeless conditions that constitute punishment. So in the Wolfish case, the U.S. Supreme Court reviewed the various practices of the Metropolitan Correctional Center in New York City in an effort to clarify the dividing line between reasonable detention policies and punishment. And so that case is located on page 446. And again, while these detainees, while they're being detained in this short-term facility pending their hearings, they are subject to reasonable regulations and to ensure order and security of the institution. But because they have not been convicted yet, they may not be subjected to any type of arbitrary or purposeless conditions that might constitute a punishment, because they're not convicted, so they're not being punished yet. Does that kind of make sense? So that's the Bell versus Wolfish case. So, and then in all cases, of course, remember the Sixth Amendment. In all cases, the accused shall enjoy the right to have assistance from counsel. And a couple of big cases in there would be, of course, the Powell versus Alabama case, but more so the Gideon versus Wainwright case, because the Sixth Amendment does provide that accused shall enjoy the right to have the assistive counsel for his or her defense. So that first case, just to kind of give you a little bit of information on it, because I don't think we've covered the Powell versus Alabama case. The first major U.S. Supreme Court judgment addressing the right to counsel was the case of Powell versus Alabama. And as you may recall from reading, because I know you read all the chapters about Powell in Chapter 2, this is back in Chapter 2, the Supreme Court relied on the Due Process Clause of the 14th Amendment in holding that, in this case, the Scottsboro boys had been denied their fundamental right to legal representation. And the Supreme Court overturned the defendant's convictions in this case. And during the pretrial phase, the trial judge in Powell appointed all members of the bar, if you will, to represent the defendants. And this was basically a little more than an expansive gesture, imposing no definite obligation upon anyone. And then on the day of the trial, the judge named 2 unqualified lawyers to represent the defendants and provided the lawyers with, basically limited time to prepare. And, to kind of wrap it up, in that case, the Supreme Court concluded that the trial judge basically denied the defendants time to prepare. So that was the first case. And then, of course, all about the Gideon versus Wainwright case. So as we've talked about in some other cases, the right to counsel is not limited to the trial part only, right? And we know, and I think we've learned this in previous chapters, that there's a 2-part test to determine when the Sixth Amendment right to counsel attaches. Formal charge issued by the prosecutor, or when a case is brought against the accused at arraignment or preliminary hearing. Or, remember, we talked about it, when that adversarial piece attaches. And that was we talked about the Kirby versus Illinois case. So these are critical stages of the prosecution. Any phase of the prosecution that may negatively impact the defendant's ability to prevent a defense at trial, and at which the presence of an attorney would have safeguarded the defendant. So hopefully that kind of makes sense. And that was the Kirby versus Illinois case. So again, that critical stage. So with that being said, and we've talked a lot about the Gideon versus Wainwright case, and we've talked about the meaning of criminal prosecutions. Remember, as it relates to determining the inability, let's say, to pay, or determining indigency, this is kind of from state to state. So it varies from state to state. And individuals who do not meet the standard in a state may apply to the court to be recognized as indigent on the grounds that they have, let's say, significant health costs, or child support, or other extraordinary financial circumstances. Perhaps they are on public assistance, which is receiving various types of assistance for family needs, like food stamps or Medicaid or other supplemental security or income. And maybe even their income alone, receiving an annual income after taxes of, let's say, 125% or less of the current federally established poverty level. Or perhaps even available funds, the inability to pay, the anticipated cost of an attorney for a case before the court as a result of, hey, I just don't have the sufficient funds to do that. So, these are some ways that the courts will determine your ability to fall under the category. What about selecting a right, or your own attorney? So a defendant has no right to be represented by a specific appointed counsel. And there's a case, Morris versus Slappy, where the public defender assigned to represent Mr. Morris was hospitalized. And here the U.S. Supreme Court upheld the trial court's refusal to grant Morris a continuance, and a decision to assign a new lawyer to represent Morris occurred. And the court reasoned that there's no right to a meaningful attorney-client relationship, and explained that a court cannot guarantee that an attorney and his or her client will share a close working relationship So basically what they're saying is that there's no right to a specific attorney. You are entitled to an attorney. Now, a non-indigent person or a defendant does possess the Sixth Amendment right to be represented by a lawyer of their choice if they decide to pay or hire their own attorney. But again, a defendant does not have the right to be represented by an individual to be able to pick an appointed counsel unless they want to hire their own attorney. And also, a defendant does not have the right to be represented by an individual who is not a member of the bar, by a lawyer who has a conflict of interest, or by a lawyer that they cannot afford to hire. So again, there are some different variations here. And in another case, Strickland versus Washington, a defense attorney possesses the overarching duty to advocate for the defendant's cause and to bring to bear such skill and knowledge as will render the trial a reliable adversarial testing process. So part of this is to make sure that when you hire an attorney, that you are entitled to the right of effective counsel. So the adversarial process in a criminal trial, then, we know it involves a contest between, let's say, a zealous advocate, the prosecutor, who represents the interests of the government, and a defense attorney who represents the defendant. And as noted by the Supreme Court, a defense attorney does possess this duty to advocate for the defendant's cause and to bring as much skill to the table, as much knowledge to the table that will render the trial a reliable adversarial process. Because otherwise there's going to be an ineffective counsel type situation, right? So that kind of makes sense. So what is the test when we're talking about seeing if there's ineffective assistance of counsel? Well, one would be deficient performance, and the other would be prejudice. So the Supreme Court has recognized that the adversarial process functions effectively when both the defense and prosecution are represented by competent lawyers. And again, the court held accordingly in that case I talked about a minute ago in Strickland versus Washington, that the Sixth Amendment guarantees an individual, both indigent and non-indigent defendants, representation of effective counsel. The right to effective assistance of a lawyer is crucial to a defendant receiving a fair trial. And a lawyer who is ineffective, in essence, deprives a defendant of the competent representation expected of an attorney under the Sixth Amendment. So the right to effective counsel applies at the guilt or innocence phase of trial, as well as the sentencing and even at a defendant's first appeal of their conviction. So the U.S. Supreme Court has held that there is basically this two-pronged test for ineffective assistance or ineffective counsel. And one is kind of self-explanatory. It's the deficient performance. And the second one would be prejudice. So absent the attorney's error, the question is whether there is a reasonable probability that the result would have been different, if there was some type of prejudice. So hopefully that kind of all makes sense. And then there are other factors. Ignorance of the law, failure to investigate, let's say, capital offenses, the attorney not required to help his or her client break the law. So these are some other things that kind of fall into play, right? So perjury, and even closing arguments, or conflicts of interest. So all of these, again, can fall into that area of making sure that you have proper representation. So I put a chart in here to help you kind of be able to identify, if you will, the critical stages and the right to representation. And you can see here that an arraignment, yes, you're entitled to representation. The preliminary hearing, yes. The post-indictment lineup, that's after the indictment. The custodial interrogation, plea bargaining, the trial, sentencing. But remember, we talked earlier in other chapters, for a photo lineup, no. For a handwriting exemplar, no. For a DNA swab, no. For a pre-indictment lineup, no. And for just a bail hearing, no. So here again, stages of criminal process and the right to an attorney. But what if you want to represent yourself? Has that ever happened? What if a defendant decides or insists on representing him or herself at trial? Now, the term is called acting pro se, or on his or her own. And you may have also heard the term pro per, which kind of means the same. Now, recognition of a right to self-representation would seem at odds with the U.S. Supreme Court's conclusion in Gideon. Remember the Gideon case, that individuals, who represent themselves are unable to present that effective defense, right, in a criminal charge. Well, in 1975, there was a case called Ferretta versus California. And here the Supreme Court held that the trial court had unlawfully refused to permit Anthony Ferretta to represent himself in a prosecution for grand theft. And in this case, Justice Stewart reviewed the history of self-representation in England and in the American colonies and states. And afterwards, he concluded that the Sixth Amendment provided a constitutionally protected right to the accused to represent himself or herself. So a refusal to permit a defendant to represent him or herself could result in a reversal on appeal of the verdict for the trial. So again, now this decision was based on several policy considerations. One was basically personal choice, meaning the right to make the choice. Next would be the consequences, that the defendant suffers the consequences if their defense fails. Next would be respect for the law, basically compelling a defendant to accept a lawyer will lead the accused to question the fairness of the justice system and may result in the reluctance of the accused to cooperate with their attorney. And then finally would be strategy, that there may be instances in which self-representation might benefit the accused by, let's say, eliciting sympathy from the jury. Because there may be times that it might actually work, right? So kind of an interesting thing. So what are some limits on self-representation? Well, Justice Blackmun, in his dissent, objected that the decision in Ferretta formally recognized the constitutional right of an individual to make a fool of himself. And here, a judge is not obligated to warn defendants of the risks of representing themselves. The Supreme Court requires judges only to inform defendants of the charges against them, their right to an attorney, and possible punishment. And to relinquish their right to appointed counsel, defendants must unequivocally waive their right to counsel and invoke the right to self-representation. The decision in Ferretta suggests that there are three limitations on this self-representation part. The first would be notice, that the defendant must notify the court in advance and not interfere with the trial court schedule by asking at the last minute. Number two would be competence, meaning the defendant or defendants must be competent to stand trial and represent themselves. They don't have to really know the rules of evidence or law, but they have to be competent to stand trial and competent to represent themselves. And then finally, disruptiveness. Defendants who interfere with the conduct of the trial will forfeit their right to self-representation. And then there was one final case, and this was McCaskill versus Wiggins. And this is where the U.S. Supreme Court decided that maybe they can appoint standby counsel. So should an individual need assistance. So in this case, the U.S. Supreme Court upheld the practice of appointing standby counsel to assist somebody with their defense. Now, the standby attorney, if you will, was not to interfere with the defendant's decisions at trial or overshadow the defendant by actively participating in the trial. There is no constitutional right to this kind of hybrid representation in which the defendant and the lawyer divide responsibilities. And there is also no right to self-representation on an appeal. So just, again, some kind of interesting information that comes forward. Okay, so that we got through that fairly quickly. That's going to conclude part 2 of our Chapter 12 lecture, the initiation of the legal process, bail, and the right to counsel. So until next time.